Good afternoon, everyone. So today my topic is food service, permitting, and code enforcement changes from the 89th Legislature. But then I start thinking, a lot of you don't do code enforcement. A lot of you, your cities may not even have noise ordinances. You don't regulate food industries. So I wanted to make sure it was relevant to everyone. So I actually snuck in a preemption topic. So what do you do when you have a perfectly good city ordinance and the state comes in and changes the law and you're now preempted? So we're going to talk about all the recent changes and then talk about how you should actually look at them and what you should generally do when you're presented with a preemption issue. All right, so today we're going to talk about preemption generally, what it is, what it looks like, and then we're going to look at the actual bills. So SB 1008 changes, that's the big one from this last cycle. It talks about a lot of different things, but the big buckets items for today are going to be your alcohol permit fees, your noise permits, noise ordinance changes, and food trucks. And then finally, I'm going to flag HB 2844. That's also a big one. At this point, we don't know a lot of the changes that are going to come from that one. I'll talk about that a little later, but I wanted to flag that for you today as well. All right, so preemption. What is it? All right, so a municipality may only enact an ordinance that is consistent and does not conflict with federal and state law. But what happens when the state passes a new law that then conflicts with an already existing ordinance, one that was perfectly valid, perfectly fine when you passed it? Well, that's preemption, or at least that's the form of preemption that we're going to talk about today. So that can come in a variety of different forms. The big ones are going to be implied or express. So express preemption occurs when a federal or state law has a provision that plainly, expressly prohibits state and municipalities from legislating in that area. So here, this comes up a lot in different court opinions and AG opinions. What the statute allows, a city may not by ordinance forbid. All right. So an example of that is going to be at the very beginning of the Penal Code, section 108. So that just very plainly says, hey, no governmental subdivision or agency may enact or enforce a law that makes any conduct covered by this code an offense subject to a criminal penalty. It says, hey, if it's in this code, we already have discussed this, we've already laid out the parameters, you cannot go above and beyond that. Now, my favorite personal example of this comes from the Parks and Wildlife Code. It says European starlings, English sparrows, and feral rock doves, which I had to look up and find out. Those are all the species names for pigeons. So pigeons may be killed at any time, in any manner, and their nests may be destroyed, and such conduct does not constitute an offense. So that's the black letter law in state law. So ordinances cannot prohibit the killing of pigeons. Not sure of any cities who have tried to do that, but if you have, the Attorney General has an opinion that says, sorry. And then implied preemption. What's implied preemption? Well, there's two subcategories there. This is from a court opinion. It says a federal statute implicitly overrides state law, either when the scope of a statute indicates that Congress intended federal law to occupy a field exclusively, that's important, or when state law is in actual conflict with federal law. So there's two parts of implied. There's either it's field preemption, so that is so exhaustively done, it's been such a comprehensive code or legislative change that it's clear that the federal or state legislature intended to fully occupy that field and there's no room for local government to come in and legislate. And there's also actual conflict, where even if there is an express preemption, even if there is an actual, if there's anything to suggest that state law didn't want local governments to come in, if the black letter law just automatically conflicts, well, you're preempted there as well. All right, so a great example of field preemption is immigration. There's nothing that directly says that that's the case. It's not a constitutional provision, but it's so heavily regulated by the federal government that it's clear that the federal government intended to fully occupy the field. So there is no room for the state or local governments to come in and make new laws on top of current immigration code. Right? And then conflict preemption. This is the most common one. It'll come up here in the examples for today. It's just, hey, even if they don't say that there's necessarily preemption, if the actual law itself conflicts with local law, you get preemption. All right, so what next? You have a local ordinance, you have a rule, you've been following it for years, the new law kicks in, it goes to effect September 1st, you're preempted. Well, what do? Well, first of all, don't panic. Your whole ordinance isn't tossed out just because of the new law. Only the preempted parts are. That's why in most of your ordinances, at least I'm hoping, most of your ordinances come with a savings clause that says, hey, if this is declared unconstitutional or if parts of it are declared illegal, those parts are thrown out, but the rest of your ordinance is still safe. As long as the rest of it is still comprehensive, cohesive, and works together, you're fine. The rest of your ordinance can still be enforced, is still in place. And then don't rush to make changes. If you rush to make changes, you can make the change worse. It keeps you from adapting in the future, and it could make the problem much harder to fix in the long run. So really, you want to take the time to review so you can make the least amount of changes to policy, enforcement, or finally the ordinance itself as necessary. Because it could be that the ordinance as written is not preempted. It could just be that the way that you as a city enforce that law or process that law, that could be the preemption problem. So it could be a procedural problem. You could fix it by changing administrative rules. So you want to take it slow and make sure you are only making the changes you are required to make. All right, so let's put this into action and look at the actual changes from this last legislative cycle. All right, so SB 1008, that was described as the Texas Restaurants Association signature bill of the 89th session. The substance of the bill was focused on changes to fees, permitting, and code enforcement of food service businesses, primarily restaurants, caterers, and food trucks. There were a lot of changes, but the ones we're going to focus on today are going to be your alcohol fees, your noise ordinances and noise permits, and food trucks. All right, so for alcohol fees, one of the changes was there an amendment to the Health and Safety Code that says, notwithstanding any other law, a municipality may not charge a fee under these two sections. For reference, those two sections are your beer and liquor sections of the TABC, and they allow counties and local governments to charge the local equivalent of the TABC permit fees. But you cannot do that anymore if the premise is a food service establishment that has already paid a fee to operate to the department or to any county, municipality, or public health district. Oop, wrong way. All right, so what that means is that if a food service establishment has paid a fee for any required food or health permit, either required by the city, the state, the health department, the county, or a public health district, then the city cannot charge a permit fee for an alcohol permit. That's a big one. When we first read this, or I'll just say, when I first read this, I misread this bill. I thought it was trying to say, if you'd already paid a local permit fee for the alcohol to the county, then you as a city can't charge it. But no, but it's not just the alcohol fee. It's saying you can't charge the alcohol fee if they have paid any fee, including health fees. So universally, that means that you will probably never be able to charge for one of these fees again, but that's not always the case. So does that mean that you should immediately amend your ordinance to no longer require a permit fee? Or should you go further and then not require an alcohol permit at all? No, that's not what I recommend. The way this amendment is written is not a blanket ban on permit fees. Now, the way it's written almost universally means you won't be able to no longer collect it, but there are many reasons to keep your ordinance as is or wait until you're ready to make changes. Let's look at some of those reasons. First, laws can be overturned. If you believe that this preemption is unconstitutional or otherwise illegal, then it may be worth keeping the law as written in case another city takes that legal challenge and it's tossed out, or if you as a city want to be the spearhead of your own lawsuit. Laws can leave gaps. Here, for example, it requires the food service establishment to have applied for and paid for a different permit fee. Now, if they're a smart business, they will apply for fees in the correct manner to avoid this fee. But they may not be. So if this is the first fee that they apply for and the first fee that they pay for, you can still charge it. So you just want to keep record of that and make sure that if you have a permit application, that they fill out and explain, hey, this is the first permit fee that you've done. So that's a procedural change you might want to do before jumping straight to the ordinance. like, hey, can we look at our paperwork and find a way to streamline our paperwork to keep this in? And then also absent full preemption, there are edge cases where having the original language can give you more flexibility to adapt to any partial preemption. That's not really a great point here, but it does apply in other cases. And then additionally, while the permit fee may be preempted, the new law does not throw out the permit structure entirely. It just says the city cannot require a local fee, not that you can't require a local permit. So if you think that this permitting structure is important enough, if you want to have a registry of the local businesses that serve alcohol, if you have good local reasons to still keep the permitting structure, you can. You just won't be able to charge a fee for it. So yeah, you can't throw the baby out with the bathwater. Just because you can't charge a fee for it doesn't mean you may not want to keep it going otherwise. All right, and then the next category is for noise permits and violations. So this is a very partial preemption because it does not completely preempt noise ordinances, but it does carve out two specific activities that cities can no longer require noise permits for or issue noise violation citations for. But it's only for these specific activities. So the first activity, overnight deliveries. So if the establishment accepts deliveries between 10 p.m. and 5 a.m. and delivery lasts for less than 1 hour, it's only for food, non-alcoholic beverages, food service supplies, or ice, and the delivery sound level when measured from the property closest in proximity does not exceed 65 decibels, then the city cannot require a sound permit or otherwise hit them with a noise ordinance violation. So yeah, so that is very narrow. If the food delivery is outside of those hours, this does not apply. If it lasts for more than an hour, it no longer applies. If they're getting alcoholic beverages delivered, it no longer applies. And then if the delivery sound level is over 65 decibels from the closest residential property, it no longer applies. So again, this is a procedural change you might want to make. Make sure your code enforcement are aware of these carve-outs so that they don't issue citations for these carve-outs or require the business to obtain a permit only for this activity. But otherwise, your noise permit ordinance is still valid. And then the second category that's exempted out is amplified sound use. And again, this is quite narrow. It's if the restaurant uses amplified sounds for playing music or amplifying human speech within their indoor or outdoor property boundaries, so it has to be within the property, as long as they're not using the sound after 10 p.m. on Sunday through Thursday and 11 p.m. on Fridays and Saturdays, and it doesn't exceed these sound thresholds at the perimeter of the property, then the city cannot require a sound permit or otherwise hit them with a noise ordinance violation. But even that, as narrow as it is, it's narrowed even further because that exception does not apply to a food service establishment on property that's located within 300 feet of a residence that was occupied before that business was a restaurant. So that may take some legwork, but you can keep it, your records of, hey, when did this restaurant start? Was there a restaurant on that property before this restaurant went into business? And are there any residential properties that are within 300 feet? If so, when were those occupied? So again, you just have to be careful. You have to look at the carve-outs. You have to make sure that you're following the rules. But as long as you're following the rules and you're not issuing these violations when you're not supposed to, the rest of your ordinance is fine. There's no preemption there. You don't have to make any changes. So the important takeaway here is that if the food service establishment is violating the noise ordinance for any other reason beyond these two carve-outs, they can still be required to obtain a permit or be issued a violation. All right, the last category for today are food trucks and mobile food vendors. The big change for this bill is going to be that the big one, restaurants and food trucks don't need to have separate permits now to deliver and serve food prepared in their permitted place, which is usually going to be either a home commissary or their actual mobile kitchen. Used to, in some cities, you'd have to have a permit for that, and then if you went to serve the food at an office building, you need to get a temporary permit for that activity as well. Now, as long as they're properly permitted in their base station, then they don't have to get a secondary permit. So you want to keep an eye out for that. And then finally, I won't spend too much time on this one, but I did want to talk about HB 2844. because that one is going to have some changes that will kick in this year. So it had two big takeaways for this bill. First, for small-scale food businesses, this won't be as relevant for most cities. But if you have a food manufacturer or use like a local farm, because it's defined as a legal entity established by a farmer or a food producer with less than 1.5 million annual gross revenue, they get some carve-outs here. So the changes that they get is that they can't be required to obtain a permit or pay a permitting fee to operate a food service establishment, retail food establishment, or retail food store if they already have a permit by the state and they're licensed as a food manufacturer. So in some places, especially if there's farmers markets, that may come up. But then the big one for today that I want to flag to keep an eye out for is there are lots of local preemption here. And like, there's actually a new section. It was titled Local Preemption. So this section of the code now says, this chapter preempts the local authorities' power to prohibit or regulate mobile food vendors in a manner that conflicts with this chapter. So that's an entire local preemption, and it's pretty wide. The state is going to come in and take over inspections for these mobile food trucks and mobile food vendors. We don't know exactly what that looks like yet. This bill goes into effect July 1st of this year. Food trucks will mostly be permanent inspected by the state. The state will be responsible for inspections, but it's looking like the health department may enter into a collaborative agreement with cities for conducting those health inspections, for which the health department will reimburse the city. So right now, all this is done separately. The city handles the inspections, or the county will handle the inspections. You have an ILA. And then the mobile food vendor will pay the permit fee directly to that entity. Well, now it's all going to be going through the state, and we don't know exactly what those rules look like. The health department is supposed to publish by May 2026 what those rules will be, but it's looking a lot like the end result will be very similar. You enter into an agreement with the state, but for the mobile food vendor, it's going to be the same. They still have to come in, they pay this fee, the fee goes to the state, but then the state reimburses the city. So we don't know what all these changes are going to be, but keep an eye out, May 2026. There's going to be a bunch of new rules. There's going to likely be preemption there. So I just wanted to flag that. That's really all I have for today. If you have any questions, I'll be either on the back or on the sides. Feel free to come up and say hi. Thanks, everyone.